record in the matter of the people of the state of Michigan versus Shawan Marquis Calvin, file number 23-03121. Council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Karen Robinson, Assistant Public Defender for Mr. Calvin.
It was the date and the time that was set for a preliminary examination for police officer assault and a domestic violence. My understanding is that there is going to be a plea, but I don't have any documents.
So yes, Your Honor, there is a plea. However, part of the plea was that Mr. Calvin has another misdemeanor file that was going to be in front. After checking both the prosecutor system and JIS, I'm not sure if Mr. Calvin has been arraigned on that, as there is no district court file number for that yet, and there's nothing in the JIS system. So I wasn't sure how the court wanted to address that on the plea sheet. If we could just put that the misdemeanor file will be dismissed, and when he is arraigned and the file is issued, we can dismiss that, or.
That sounds like not so promising. It's not even been issued. No one will know that this plea is there.
The complaint has been signed, Your Honor.
Okay.
I'm not sure.
It's been signed. There's a case number.
Yeah, I don't think it's been. I don't know if he's been arraigned on it yet either, Your Honor.
Is there a case number?
There is not.
Well, then there's not been a file open yet. We'll go off the record. Do you know when it was signed?
I believe I signed it back, because I'm the one who signed it, Your Honor.
Oh, it was signed by you. It wasn't signed by a judge.
Oh, signed by a judge. I'm not sure.
So has it been issued?
Fine. Yeah. I cannot say if it's been sworn to me yet or not, Your Honor.
Okay, and when did you sign it?
October 3rd, Your Honor.
Today's November 3rd. If it hasn't been signed by a judge by today, you got to re-sign it. Someone has to re-sign it from your office. So that means that the officer is holding on to it for some reason. This is the only thing I can presume. Once we sign it, it's in our system within 48 hours. So it could have been seen by a judge and sent back. I don't know what happened, but I can't take a plea and then there's no case number for that note to go into. He'll still get a warrant once that goes in the system. If you want that to be incorporated, the best thing is to put this out until that is issued.
Yeah, that's fine.
Yeah, okay. Go back on the record, Your Honor.
Okay, back on the record in the matter of Shawan Calvin. And so our understanding is that the other case, the misdemeanor case, has not been issued yet, but that you want to incorporate that into this plea agreement.
Yes, Your Honor. And so the people would ask for a good cause adjournment so that that complaint can be issued and incorporated into this plea, Your Honor.
We would have no objection to that.
Okay, so I'll go ahead and find the cause to adjourn this matter. Mr. Rodowitz, you should follow up with whoever you sent that misdemeanor back to see if they had it authorized, because if not, then it's gonna have to probably be redone.
Yes, Your Honor.
And then if it does need to be redone, you can just send it to me. We can get it taken care of and get it to the system in time for this next court date that I'm about to give you. November 16th. 9:30. November 16th at 9:30. Do you have any questions today? Okay. Any additional matters for the record, Mr. Rodowitz?
Just real quick, is that being set for a plea, Your Honor, or for another?
Set for a plea.
Okay. I wanted to know if I could let my office know.
No witnesses need to appear.
Right.
Any additional matters, Mr. Robinson?
No, Your Honor, thank you.
Thank you. We'll get you a copy of your notice to appear, okay?
Okay.
All right, ma'am. On the record in the matter of the people of the state of Michigan versus Jason Bruce Linton, file number 23-02146. Appear, please, counsel.
Jeff Brodowitz on behalf of the people, Your Honor.
How are you, Mr. Blackman? Okay, today was the date and the time that was set for sentencing. I have a pre-sentence report and recommendation, and you prepared back on October 27th. Did you get a copy of that report?
I did. My client.
I'm sorry, could you speak up a little bit?
I'm sorry. I have got a copy of that, Your Honor. I've been on Zoom with my client. He went over with Mr. Abbott before I subbed him. I went over it again with him today. So we're ready.
Okay, no need to make corrections, updates, or deletions?
No, Your Honor. The only update would be a email that I gave to the court today from Turning Point.
Okay.
And that would be it, Judge.
You can make allocation.
Judge, I've been retained by the relative of my client in reference to turning him in back in Eaton County. We've got some warrants on it. They did not complete programming down in Eaton County. As soon as we completed this particular matter, we will be in the process of doing that. We will agree with the recommendation that the court consider.
Thank you. Does your client want to make a statement at all?
Not sure.
Mr. Linton, did you want to make a statement for yourself, or are you relying on the statements by your attorney?
I just want to let the court know I'm doing my best to get my life back. I just didn't want it before, and I'm sticking to it. And backwards is not or down is not an option for me. I'm going to complete the program, no matter what I have to do. So I'm trying to get my life back, my family's back in my life. So that's a big plus for me. I have more support, and I feel great. I feel better.
Okay. The recommendation indicates that your client is not a good candidate for probation and recommends it's sentence of jail time. You understand that?
I understand. They've also indicated there that we would be asked the court to complete and do day for day for inpatient.
Okay. Okay. I believe, and you're currently at Turning Point, because I do
Yes.
have an email here
Yes, ma'am.
from a Melissa Clark indicating that you are having a typical stay is 14 to 21 days after completing detox, and that you were admitted into that program back on the 30th of October. So not even a full week, correct?
Correct.
So I'm happy to hear that you are doing some treatment and that you're on your road to recovery. And so I think the recommendation is appropriate, and I will adopt the recommendation, and I'll sentence you to a term of 180 days Eagan County Jail with credit for 14 days. 166 days will be suspended upon successful completion of your residential treatment, okay?
Yes, ma'am. Thank you, Your Honor.
Thank you. Do you have any questions today?
No, Your Honor.
Any additional matters for the record, counsel?
No, yeah.
Okay, good luck to you, Mr. Linton.
Thank you, Your Honor.
You're welcome. We reset, you wait already?
I didn't know if you wanted to do that on purpose. But I gave him a name already.
Yeah.
Okay, both attorneys? Okay. Are we running Robinson?
I believe both of those are around.
Just see Mr. Iverson, but he's gone. Hello, on the record in the matter of the people of the state of Michigan versus Tina Joy Moon, file number 20-02233, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Tina Moon, Your Honor, who's not present this morning. Your Honor. I'm not sure her whereabouts. I've not, but I know from reading the pre-sentence investigation report that that was not completed, so I'm not sure. Her whereabouts.
I will show big sworn bond forfeiture.
Thank you, Your Honor.
Thank you, all set. On the record in the matter of the people of the state of Michigan versus Russell Vincent Dawson, file number 23-02744, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And good morning, Your Honor. May it please report Christopher Coyle, P 49708, appearing on behalf of Mr. Russell Dawson, who is here and to my right.
Okay, today was the date and the time that was set for preliminary examination. I understand that there was an offer. I don't have a plea sheet, so.
We are executing that right now.
Just a regular. It says here, the people are offering for you to plead guilty to an added count 2 of assault or assault and battery, and that they would dismiss count 1. Is that a complete and accurate understanding of what you were offered?
Yes.
Okay, you want to accept that offer, sir? Please raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
I did.
If you could put your hand down. The advice of rights of plea information sheet with today's date on it, and there's a signature on the bottom. Is that your signature?
Yes, ma'am.
Did you read this document?
Yes.
You understand the rights listed there? Do you have any questions about any of these rights?
No.
You want to give up each of those rights today in order to enter a guilty plea to the added count 2 of assault or assault and battery?
Your Honor, can I interrupt for one moment? We are plea is to no contest, or we're going to plead no contest because of potential civil liability.
I don't see that on here, nor do I see that in the email.
I can amend the plea sheet, Your Honor.
I'm sorry.
I can please approach here.
And then I need a police report. You highlight the relevant portions. We'll go off the record while you prepare.
Thank you.
Mr. Abbott, find his client. Is Ms. Donnelly here? Here's what's going on with this. Do we have a report?
Commissioner Procher.
Yep.
Should be amended plea sheet with the highlighted portions of the police report.
Okay, we're back on the record in the matter of Russell Dawson. Okay, so the offer is being amended to a no contest plea. And the reason for that is you said civil liability.
Yes, Your Honor. Thank you very much. I apologize for the pause.
And so you want to plead no contest to assault and battery?
Yes, Your Honor.
Okay, still, you would need to give up each of these rights to do that. You understand that? So you understand that you have the right to the presumption of innocence. So you're innocent until proven guilty. You understand that?
Yes.
And you have the right to require the prosecution to prove your guilt by having a jury trial and having them prove each element of the charge being brought against you beyond a reasonable doubt at that trial. At the time of trial, you have the right to remain silent and not have silence be used against you. You have the right to confront in court any of the witnesses or your accusers at trial and cross-examine those witnesses. You understand that? You have the right to call your own witnesses or present evidence at trial that you believe further a defense to the charge being brought against you. You understand that? And you're willing to give up each of those rights today? Anybody threatening you to get you to waive those rights? Has there been any promises that induced you to waive those rights?
No.
Are you currently on probation or parole?
No.
You understand that if found to be guilty, a conviction of this kind could impact travel or immigration status that you may be seeking, such as you may want to go to Canada for vacation. Okay. You also understand that entering a guilty plea a no contest plea could result in a conviction that you may need to report to your current employer, or you may need to report this on a future job application. You understand that? And you want to still waive your rights with that understanding?
Yes.
Okay, there's not been any sentencing agreement, correct? I don't see. Okay, okay. As to the amended charge, assault and battery, how do you plead?
No contest.
Okay, I have a police report here from May 15, 2023. Case number 23519044450. Officers indicated that at the area of the 600 loft unknown apartment number, but it was in city of Lansing, Ingham County, state of Michigan, on the date of 5/14/2023, and the time between 0200 and 0300 hours. Officers took a statement from the alleged victim, being Ivana Ruiz or Ruiz. Ruiz stated that she was present at that address, and that a few minutes later, she had a hand under her bra and shirt grabbing her breast. Ruiz stated she jumped up and saw Dawson lying across Miller. She ran out and she grabbed her shoes. This is all that was highlighted. That is not a factual basis for an assault battery. Nothing in what was highlighted tells me that that was him who did that.
Commissioner Procher.
Yes.
With regard to the factual basis, if I may, Your Honor, we can, counsel, you can stipulate that it was an unwanted touching.
Yes, I would say.
I'm not concerned about that. All I got on there was that she woke up and there was a hand on her, and there's two other people's names mentioned in that highlighted section.
And
So nothing in that report.
the
tells
hand
me that
was Mr. Dawson.
Where in that report is that saying that? This is a no contest plea, so.
Commissioner Procher.
Thank you. Okay. Officers made contact on June 13, 2023, with Russell Dawson over the telephone. He indicates he remembers touching the, it's her shoulders, it's hers, should be interpreted to be the alleged victim, and that was it. The additional factual basis.
Nothing from the people.
No, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. The matter will be set for sentencing.
Your Honor, would the court entertain immediate sentencing?
Is the victim here?
I do not believe so, Your Honor.
Well, then there's a Crime Victims' Right Act that requires me to set it for sentencing. Does the 29th of December work for you?
December 29th? Yes.
Okay, so we'll do sentencing December 29th at 8:30. That could be via Zoom. When you leave here today, you'll go down one floor, you'll meet with our probation department so they can get you set up for a pre-sentence interview. Can I see the referral, please? And you can appear via Zoom for your sentencing, okay?
Your Honor, I make one more request.
May.
With regard to bond while sentence is pending, Mr. Dawson, although he lives in the Lansing area, just down the street here, he has for 5 years. His family is from Florida. His parents live there, his son lives there. And I'm asking permission from the court to grant Mr. Dawson permission to leave the state of Michigan over Thanksgiving to go with his parents and his son in Miami.
Yeah, I'll grant permission from the travel for Thanksgiving. Giving in, I'll give it for Christmas so I don't get another request later, okay?
Appreciate it. However, we will be back on the 29th.
Appearing via Zoom, obviously.
Oh, yeah, that's right.
I understand it's a couple of days before New Year's Eve. That's why I make sure you were available. Anyways, with that being stated, you'll go downstairs, you'll check in with probation so they can get us a pre-sentence report. They're gonna give you a date for an interview after that pre-sentence paperwork is completed. You need to get that paperwork back to them as soon as possible, and then they'll get it all set up for your interview. So you're going down today, but you're still gonna have an interview. Some people get confused by that. You gotta also appear for your interview. Otherwise, I'll have to remand you at your sentencing if I don't have a completed report, okay? Do you have any questions at this time? You can read that police report back, please. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you very much.
I gave them the date already. I just know.
What's the date?
Yeah.
On file. Just sent an email regarding it. Email saying, right.
Ms. Robinson,
Yes, sure.
I think you have somebody, you get a waiver?
Yes, on Mr. Street.
Thank you. On the record in the matter for the people of the state of Michigan versus Davon Meyer Street, File number 23-02828, council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Street.
Okay, Mr. Street, how are you today?
Bless her.
Very good. Today is the date that was set for a preliminary examination, and my understanding is that there is a conditional waiver to the circuit court. Is that correct?
Yes, Your Honor, I believe that is correct.
That's correct.
Was there an offer?
At this time, Your Honor, I believe there was no offer in district court. So sorry, my apologies. The offer would be to plead to the charge of carrying a concealed weapon with no objection to HYTA if eligible.
Is accurate, Ms. Robinson?
It is.
Okay. Okay, Mr. Street, you understand that you have the statutory right to have a preliminary examination in the district court? You understand the purpose of the exam? Okay, that's to require the prosecution to meet their burden of probable cause. So they got to put on enough evidence to satisfy probable cause that a crime was committed and then probable cause to charge you with the crime. You understand that? Do you want to unconditionally waive your right to that examination?
Yes, Your Honor.
Anybody threatening you to get you to do that? Any promises being made to you to waive your exam? Did you sign this paperwork?
Yes, Your Honor.
Okay. Bind your matter over for a bind over date of November 15th. That's the date the circuit court's gonna get this file from this court. You don't need to appear in court on November 15th, okay? The next court date in circuit court will be a pre-trial unless, and for some reason, Ms. Robinson wants you rearranged, she makes a motion for that at the circuit court. Otherwise, you'll stay in contact with her. She'll get notice of your next court date, okay? Your address or number changed since September 28th.
No, ma'am.
Okay. Bond was set at 2,000 personal recognizance. That will continue. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
You're all set, sir. You're welcome. Is Ms. Donnelly here?
Judge Ward's courtroom. He's present.
Oh.
In the building.
So Abbott, did you find your client, Mr. Olivas?
Yes, Your Honor, he's present in the courtroom.
On the record in the matter of the people of the state of Michigan versus Marcos. All of this, file number 23-03154, council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott, representing Mr. Davis. He's present, standing to my right.
Okay, today's the date and the time that's set for prelim and a PA 53 contempt. Are we continuing today
Yes, Your Honor, I believe we are continuing preliminary exam today.
in PA 53?
I have not seen, I will say, of course, I have been made aware of a alleged bond violation by the complaining victim in this case. However, I do not believe I have seen any official report or paperwork on a bond violation at this time, Your Honor.
That's because I'm supposed to read them today. Okay, so I have a police report here from October 29, 2023, alleging that you violated the terms of your bond on October 29th at 2100 hours. It is believed, it's stated, we're at the address of 624 Leslie Street and harassing the protected party, that being a Clarence Christie, through third-party contact. So if true, that would be a violation of your bond conditions. And if you're found to be in violation of your bond, that would be a contempt of court. Contempt of court is punishable with a maximum penalty of 90 days in jail and or $7,500 in fines. So you have the right to have a contested hearing. And you have the right to have Mr. Abbott represent you at that hearing. Do you understand that?
Yes, ma'am.
How does he want to plead?
We'll deny the contempt, Your Honor, and request a hearing.
You'll enter plea of not guilty on the PA 53, and we will recall the case when we're ready to run the exam, okay?
Thank you.
Thank you. Mr. Michelson, which matter did you have with
I
you?
have Miss Morris, Your Honor. I have not seen her this morning, Your Honor. Like,
Have you been in contact recently?
I haven't, but here's what I think's going on, Your Honor. I know we had an exam set back in August where Miss Morris was at Sparrow Hospital. I have not heard from her since that time. I'm wondering if it ever got sent because I only learned of today's exam yesterday.
We mailed notice on September 20th.
Okay.
Well, sure, make sure that if you can make contact with her.
The only other issue is the officer that did the arrest is no longer with PD, so even if it were to appear, likely this case is may end up in a dismissal.
That's up to the prosecutor. You can still subpoena someone who doesn't work there.
Enough for me. Thank you. Have a nice day.
Same to you. Are you ready to run, Robinson?
1 second.
And then Becker, I think I already had a note on that. I'll just put it on the record.
Yeah.
On the record in the matter of the people of the state of Michigan versus Ronald Bruce Becker, file number 23-02921, counsel appearance.
Jeff Radowitz on behalf of the people, Your Honor.
Aaron Robbins, Assistant Public Defender for Mr. Becker.
Mr. Becker is not present. The court did receive communication yesterday indicating that he's currently hospitalized and they're not sure of a discharge date. I have already found good cause to go beyond the 21-day timeline, so this could be reset. I'm gonna, at this point, set it out 30 days, just because I have no idea when he's going to be discharged.
December 29th and 9:30.
December 29th at 9:30.
Will that be for PCC or PE?
RGPCC,
Thank you.
no problem. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, thank you.
You know, set
That was at 8:30, Your Honor.
9:30.
9. Sorry.
Right. So you need a minute before we call Robinson?
Yeah, I just need to see. On his way, I just need
on the record in the matters of the people of the state of Michigan versus Malcolm Robinson, file number 23-02147, and Michael Robinson, file number 23-02148. Council appearance, please.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Melissa Patrick on behalf of Michael Robinson, who is here to my right.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Malcolm Robinson. He's standing to my left.
Okay, today's date and time set for preliminary examination, and we're ready to proceed, correct?
Yes, Your Honor.
Yes, Your Honor.
Okay, any preliminary matters?
Nothing from the people, Your Honor.
None, Your Honor.
None, Your Honor. Thank you.
Can you call your witness?
Thank you, Your Honor. The people would call Officer Bailey Uberoff.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat, officer. Can you state your first and last name and spell both of them?
Officer Bailey Uberoth, B-A-I-L-E-Y, Uberoth, U-E-B-E-R-R-O-T-H.
You can proceed, counsel.
Thank you, Your Honor. Good morning, Officer Uberoff.
Morning.
Officer Uberoff, how are you employed?
As a police officer with the city of Lansing,
And how long have you been a police officer with the city of Lansing?
just under 5 years.
And what are your current duties with the city of Lansing Police Department?
Yeah, I'm currently assigned to the community service unit as a community police officer for the Kalamazoo corridor operating control capacity.
Okay, and were you working in that capacity on July 11th, 2023?
Yes,
All right, and on that date, did there come a point in time where your duties took you to the area of West Saginaw and North Martin Luther King?
yes,
And is that location in the city of Lansing?
Yep.
In Ingham County?
yes.
And what caused you to be at that location?
I conducted a traffic stop.
And why did you stop that specific vehicle?
I observed a moving violation,
What was that specific moving violation?
an improper turn.
Can you just describe a little more what you observed for the court reference?
So at the intersection of Westmoreland and West Saginaw Street, there's multiple lanes of travel. For a proper turn to be completed, you have to turn into the first available lane. I observed this vehicle take the most southern lane, which was across multiple lanes of traffic.
Okay. And so after you conducted the traffic stop, how did you proceed?
First, I observed the driver immediately put their hands out the window that I could see seated in my patrol vehicle. I then exited my patrol vehicle and made contact on the passenger side.
Okay. And when you approached the vehicle, what did you do after that?
I introduced myself as Lansing police officer and requested for their license, registration, and proof of insurance.
All right. And did the individuals in that car provide you with their information?
They did.
Okay. And do you remember the names of the individuals who were in that car?
Yes.
And what were they?
The driver was Michael Robinson and the passenger Malcolm Robinson.
Okay. And do you see the driver, I believe that you said that was Michael Robinson, anywhere here in the courtroom today?
I do.
Can you please identify where he is sitting and an article of clothing he's wearing?
He's sitting right there in the white.
Please let the record reflect the witness has identified the defendant, Michael Robinson.
Any objection?
No objection for preliminary exam purposes only.
Thank you.
And do you see the passenger, I believe you identified as Malcolm Robinson, anywhere here in the courtroom today?
I do.
And where is he seated? And can you please describe an article of clothing he's wearing?
He's seated right there in the black.
Okay. Please let the record reflect the witness has identified the defendant, Malcolm Robinson.
No objection.
So noted. So after, sorry, one sec. So when you asked for the information from the individuals in the vehicle, were you immediately supplied with all of the requested documentation?
No,
What wasn't provided to you at that time?
the proof of insurance was not provided to me.
And did you learn where the proof of insurance was?
I believe he said it was in a backpack that he was rummaging through.
Okay, and do you remember what that backpack looked like?
Yes,
And what, can you describe that backpack to the court, please?
it was a red backpack.
Okay. And then what did you do after, sorry, one second. So what did you do after the driver, or what did the driver do after he told you the proof of insurance was in the backpack?
I asked if there were any firearms in the vehicle, which the driver then told me that there was a firearm in the car.
Okay, and did the driver ever tell you where that firearm was located?
Yes,
And where was that firearm located?
in the red backpack.
Okay, and did the driver have a valid CPL?
No.
And after you learned there was a firearm in the vehicle, how did you proceed?
I requested that all occupants put their hands in front of them, the driver specifically on the steering wheel. And when a backup officer arrived, we then removed each occupant one by one at a time from the vehicle.
And were the occupants compliant during this?
Yes,
Okay, and after the individuals were removed from the vehicle, how did you proceed?
I completed a Terry pat down of their person and found them to be free of weapons and requested that they sit down on the curb outside of the vehicle, on the side of the road.
And did you ever run the individuals in any sort of law enforcement database?
I did.
All right, and what did you learn after you ran the individual? What database did you use?
Lean, Law Enforcement Information Network.
All right, and after, what did you learn after you ran them in Lean?
I learned that the driver's CPL status expired in 2020 and that the passenger had 2 outstanding felony warrants for his arrest.
So how did you proceed after you ran the individuals in Lean?
With the information that the passenger had 2 valid felony warrants for his arrest, I placed him in handcuffs that were checked tightness to the lock and advised him he was under arrest for warrants.
And at this time, did you ever inform the driver that the CPL was expired?
I did.
Okay. And did you place the driver under arrest at this point?
I did.
And why did you place the driver under arrest?
With the information that a firearm was in the vehicle and the combination that there was no CPL, he was placed under arrest for CCW.
All right. And did you ever find the firearm in question?
I did.
And where did you find it?
In the red backpack.
All right. And did you ever, did you document where you found the firearm?
Yes.
All right. Officer Uberoth, I'm going to show you what's been marked as People's Proposed Exhibit 1. Permission to approach here on?
Yes.
All right. You can take a look at that for a minute. Officer, do you recognize that photo?
I do.
And how do you recognize it?
As the red backpack I located inside of the vehicle during the traffic stop.
And is that a fair and accurate representation of what you witnessed that day?
Yes.
At this time, Your Honor, the people would move for admission of People's Proposed Exhibit 1.
Any objections to People's 1?
No objection, Your Honor.
No objection, Your Honor.
People's 1 is admitted without objection.
Okay, thank you. And Officer, do you see the firearm in that picture?
I do.
And then permission to approach Your Honor.
Yes.
Can you please circle in that picture where you see the firearm? Permission to approach.
Yes.
All right. And so then after you found the firearm in that red backpack, how did you proceed?
I then rendered it safe and began to walk back to my patrol vehicle to secure it and then continue the search of the vehicle.
Okay, and when you were taking it back to your vehicle, did anything happen at that point?
Yes.
And what happened?
The passenger, Malcolm, was in my vehicle. And once he saw me come back with the firearm and overheard the CPL expired status, he informed me that there was an additional firearm and a blue backpack on the passenger seat that belonged to him, and that he believed he also did not have CPL. Okay, and did you read Malcolm Robinson his rights prior to him making this statement? I did not question him. He actually did an excited utterance. Okay. And sorry, just for the record, I can't remember, did Malcolm Robinson tell you if he had a CPL or not? He said that he believed his was expired as well. Okay. That he went through a firearm course through a friend and believed that they did not submit any paperwork. All right. So after you learned there was possibly another firearm in the vehicle, how did you proceed? I then went to the passenger side where he advised the blue backpack was and opened that up and located an additional firearm. All right. And did you document where that firearm was found? I did. Permission to approach her?
Yes.
You could just take a look at, I'm handing you what's been marked as people's proposed exhibit 2. You could just take a look at that for a minute. All right. Officer, do you recognize that photo? I do. And how do you recognize it? As the blue backpack. All right. And is that a fair and accurate representation of what you observed that day? Yes. At this time, people would move for admission of people's proposed exhibit 2.
No objection.
No objection, Your Honor.
People's Choice Committee. Somebody's phone on? No, I don't want you, sorry, I want it off.
Permission to approach again, Your Honor?
Yes.
And again, officer, if you could please circle in that photo where you observed the firearm, see if that marker works better. Okay, and then if you could just recircle the first exhibit as well, since that works better. And I believe you mentioned, but where was the second backpack in question, the blue backpack? Where was that backpack found in the vehicle? On the passenger seat. Okay. And then how did you proceed after you found the firearm in that backpack? I rendered it safe and secured my patrol vehicle. And then after you recovered that firearm, how did you proceed? I continued to complete a probable cause search vehicle. Okay. And did you find anything else in the vehicle? The only other thing I found was in the red backpack was an amount of money, just unknown amount of $100 bills that was secured in the bag and brought for Michael for his business. Right. And then after you finished your search of the vehicle, how did you proceed? A tow truck was requested to respond. Then myself and Officer Erickson transported to LPD lockup, where I included an incident report. No further questions, Your Honor. Permission to publish Peoples 1 and 2 to the court, Your Honor.
Yes, please.
Thank you, Your Honor. Is it Officer Uberall? Is that how you pronounce it?
Uberall, but you just call me Bailey if you'd like.
Like with a Y. And they call you officer, correct? Or is it something else?
Officer.
Officer Uberall. You said that your regular patrol is the Kalamazoo corridor. Can you tell me exactly what that covers?
Yes. So the Kalamazoo corridor is a smaller area within the city. The boundaries are the western boundary is Pennsylvania. The eastern boundary is Mifflin. The southern border is 496 and the northern border is Michigan.
Okay. So Willow within those boundaries?
No.
Okay. Do you recall seeing this vehicle on Willow and Roosevelt?
Yes.
You do. Okay. Was there anything in particular that stood out about that vehicle on Willow and Roosevelt?
Not at Willow and Roosevelt.
Okay. Was there a point in time when you got behind that vehicle and followed them onto MLK?
Yes.
Okay. And was there anything particular about the vehicle then that made you follow it onto MLK?
I was headed towards MLK, and almost immediately after turning on MLK, the vehicle made a right-hand turn to, I believe, the first available street.
Okay.
However, I continued to the next one.
Okay. And when you effected this stop, you were behind them already, correct? When you effected the stop after you say they made the unlawful turn, you were already behind them before they made that turn, correct?
Correct, at the stop sign at Westmoreland. Exactly.
How did you get back behind them if you passed by after they turned off of MLK? How did you get back behind them on Westmoreland and Saginaw?
Yeah, so as they made that first turn into the first available street, I went to the next one. I was able to then go down that same street and make it to Westmoreland, where I just continued as normal traffic and observed the vehicle back at the stop sign at Westmoreland. I eventually caught up to them.
Okay.
And that's when the improper turn occurred.
Okay. Now, how many traffic stops do you affect per day on average, thing?
Roughly 4.
4? Sometimes less, sometimes more.
Correct.
That's safe to say. And how many of those do you ask if they have firearms in the vehicle?
Almost all.
Almost all? Is that something that you were trained to do, to ask about weapons during traffic stops?
Yes.
And I want to take you to the stop. So just for clarification, you were on Westmoreland behind the vehicle.
Correct, at the stop sign.
And that's a two-way street there, Westmoreland.
Yes.
It is, okay. So they were taking a left turn onto Saginaw.
Yes.
Okay. So that would make them, their vehicle would have been in the right lane before they're making a turn onto Saginaw, correct?
Correct.
Okay, so there would be oncoming traffic, and they were going oncoming traffic coming north, and they were driving southbound.
On Westmoreland,
Facing
yes,
south,
yes,
I'll say
yes.
that.
For Westmoreland, yes.
So they were facing
They were
south.
driving southbound,
Gotcha,
and there's an opportunity for traffic to travel northbound, yes.
gotcha. Okay. And as far as where they were turning, that was one-way traffic, correct?
Correct.
That is eastbound on Saginaw, correct?
Correct.
Okay. Now, when you say they made an unlawful turn, can you describe to me or tell me what portion of the Michigan Motor Vehicle Code you used to determine that they had made an unlawful turn?
Yes, the improper turn statute.
Okay, what statute is that?
That is that they have to take the first available lane when making the walk in.
At all times?
Yes.
Okay. Do you know that code?
Like the MCL code?
Yeah.
I do not off the top of my head.
When was the last time you reviewed that code?
I don't know.
Okay, but you used that particular code to determine that it was an unlawful stop, unlawful turn.
Yeah, I use that as a violation that occurred today.
Did you write a ticket?
I did not.
Okay, and why didn't you write a ticket?
Because I felt as though the felony CCW charge was appropriate rather than also issue a citation.
Okay. So you don't recall exactly how the language reads in the code?
Not word for word.
If I were to show you that code, would that familiarize you or reacquaint you with how it reads?
Yeah.
Okay. John, do you have this code?
Are you referring to 257.647?
Yes,
I do have it.
you have it. Have you seen this one? And as Mr. Abbott so eloquently read out, it is code MCL 257.647. Permission to approach, Your Honor?
Yes.
And I wanted to point to you specifically, and you don't have to read out loud, you can read it to yourself. There's a section D under 257.647. I'm gonna hand it to you, but when I hand it to you, I would like for you to tell the court what I am handing you based upon this title.
You just handed me a paper with the title reading 257.647, turning at intersection, violation of civil infraction.
Okay, and I want to refer you down to section D, and I want you to read that to us as well.
Should read it out loud.
Yes, please.
Where both streets or roadways are one way, both the approach for a left turn and a left turn shall be made as close as practical to the left curb or edge of the roadway.
Okay, so that specifically states the rule that you are referring to as far as turning closest to where you are. That's in reference to turning from a one-way street onto a one-way street. Is that what you just read?
Could I? see it again?
Absolutely.
And-
Yeah. Absolutely.
Okay. Could you re-ask your question? I don't remember what you asked.
Okay, the question was, so when, based upon what you just read, the rule that you applied in this case where you stated that they made an improper turn because when they made a left, they didn't turn onto the lane that was closest to them. They went all the way over to the farthest lane. Would you agree with me that based upon what you just read, that law is not applicable to that turn that they made?
I don't, because of subsection C. Would you like me to read that out loud?
Hold on, let me look at it. Absolutely. So there's a portion of subsection C that actually applies. So yes, go ahead.
So approach for a left turn from a two-way roadway into a one-way roadway shall be made in that portion of the right half of the roadway nearest the center line and clear of existing car tracks in use. And by passing to the right of the center line where it enters the intersection. Approach for a left turn from a one-way roadway.
Well, that doesn't apply because
This is all
wasn't-
C if I'd like to.
Well, go ahead, yeah, go ahead.
All right, so approach for a left turn from a one-way roadway to a two-way roadway shall be made as close as practical to the left curb or edge of the roadway and by the passing to the right of the center line of the roadway being entered.
Right, so that portion you just read, that applied to turning from a two-way roadway, from a one-way roadway to a two-way roadway. That's just the part you were trying to emphasize just a minute ago?
When, is that a question?
Yes, you
What
were
was the question?
emphasizing this portion here. When I tried to stop you because that doesn't apply, it says left turn from a one-way roadway onto a two-way roadway. That's not applicable in this case because they were turning from a two-way roadway onto a one-way roadway. When you agree with me on that?
I would say that yes, they were turning from a two-way onto a one-way.
That's correct. So the section that applies here, you read that a left from a two-way roadway to a one-way roadway shall be made while they're on the right portion, which is where they were before they made their turn. Do you see in that portion where it specifies any lane that they should take?
Yes, I do.
Okay, where do you see that?
It says by passing to the right of the center line where it enters the intersection.
Right, so when the right that, when you agree with me, you already testified that they were driving southbound. So that would make them be in the right lane of that road. So they were coming from the right lane and they were taking a left onto Saginaw. When you agree with me?
Yes,
Okay, they were in the correct lane for making the turn based upon that statute. just
to
wrote.
start the turn. Yes.
Yes. Is there anything that specifies in that section where they are supposed to turn into?
No, it does not.
Okay. So isn't it safe to say that if you were more familiar with the actual law that you applied in that situation, you would not have affected that stop?
It's possible.
Would you have had any other reason to stop them outside of this alleged unlawful turn?
Have to re-jog my memory. However, I do believe that there was window tint on the.
But you didn't state any of that in any police reports or anything like that? Correct?
Correct.
You didn't write any tickets for any window tint or anything like that, correct?
Correct. However, there was photos, if I remember correctly, of the vehicle
Okay,
prior to being towed.
but based upon your police report and your statements here under testimony, your reason for stopping them was because of an alleged unlawful turn, correct?
My reason for stopping was for the improper turn. Correct.
Thank you. I have no.
I just need to clarify, are you sure they had a tent, or you need your?
I would need to re-jog my memory
Okay.
with a photo of the vehicle.
Okay, so you don't have another reason then, for you stopping, you are now trying to jog your memory as whether or not there was another reason why you couldn't stop them?
Right. For her question of, was there any other violation that I could have stopped them for? There, from my memory, I do believe that there was window tint. However, that was not my primary reason for stopping.
Okay, sounds good. Mr. Abbott.
Thank you, Your Honor. Can I get this marked as a defense exhibit?
Yes, please.
Approach the witness, Your Honor.
Okay.
And officer, is that the statute that you were just referring to?
Yes, this is the same paper.
And so I would ask the court to accept. And does that document accurately describe the law that you were applying it?
Yes.
Your Honor, I'd ask for admission of defense exhibit A, copy of the statute admission here.
Any objection?
No objection, Your Honor.
Defense A is submitted.
And based on listening to the questions that you had been asked, there's really no basis for that stop in that statute, correct?
For the subsection D, no.
Well, anywhere in that statute, anywhere, there's no part of that statute that requires the person driving from a two-way street onto a multi-lane one-way street has to arrive, has to turn into the closest lane. There's no rule there. There's no law requiring that, right?
Correct.
Thank you. Your Honor, I published this with the court, please.
Okay.
In fact, there's nowhere in the traffic code, anywhere else either, that makes that turn an illegal turn, to your knowledge.
To my knowledge, I'd have to review motor vehicle code, however, I don't know off the top of my head.
Thank you. Nothing further. Your Honor.
Correct.
Just briefly. So you stated, though, at the time of this incident, it was your belief, your reasonable belief that that was an illegal turn, correct?
Correct.
Okay. No further questions, Your Honor.
May this witness be excused?
Yes, Your Honor.
Thank you, Officer Uberall.
Thank you.
Do you have any other witnesses today?
No other witnesses, Your Honor.
Is the defense calling any witnesses?
No, yeah.
No, thank you, Your Honor.
Thank you, argument.
Thank you, Your Honor. The people would move that this be bound over to the circuit court as charged in the complaint on both, both file 23-02147 FY and 23-02148 FY. Here, the individuals were charged both with one count of carrying a concealed weapon. We heard testimony from Officer Bailey Uberoth, who testified that while performing his duties as a police officer in the city of Lansing, he witnessed what he believed to be an illegal turn and made a traffic stop of the vehicle that made that turn. After he performed that traffic stop, that he approached the vehicle, obtained identification from both individuals in the vehicle, and identified both individuals as both Michael Robinson and Malcolm Robinson here in the courtroom today. Officer Uberoth also testified that while speaking with the driver, I believe he said that was Michael Robinson, that Mr. Robinson admitted that there was a firearm in the vehicle. Upon learning there was a firearm in the vehicle, Officer Uberoth asked both individuals to show their hands and then proceeded to remove both individuals from the vehicle and found a firearm in a red backpack that Mr. Michael Robinson was searching through to find his, I believe he said it was the proof of insurance, or but I can't remember if it was the registration, Your Honor, my apologies. And found a black handgun and also found that Mr. Michael Robinson did not have a valid CPL. We also heard testimony that during his investigation search of the vehicle, he had an excited utterance from the passenger, Mr. Malcolm Robinson, who admitted that there was another firearm in a blue backpack that was found on the floor in front of the passenger seat, and that Mr. Malcolm Robinson believed that his CPL was expired at the same time. As for the traffic stop, Your Honor, I believe that would be an issue. Police are allowed to make traffic stops as if they have reasonable suspicion that a violation has occurred. Here, I believe Officer Uberoth has testified that he had reasonable suspicion to make that traffic stop, which would make the stop lawful. Plus, these individuals are charged with CCW. I believe the people have met their burden by probable cause evidence, and ask that this be bound over as charged to the circuit court, and that any issue with the stop would be a question for the trier, and the officer's reasonable suspicion would be a question for the trier of fact, Your Honor. And with that, as I said, the people would move that this be bound over as charged in both complaints.
What is the issue for the trier of fact?
Whether the officer had reasonable suspicion or not to stop the vehicle, Your Honor.
He said that he didn't. He said on the record and said that there was nothing in the code that he relied on that are you gonna talk over me?
Sorry,
He said on the record that there was nothing in the code that he relied on that would make his stop a legal stop. Like he said that he would not have stopped them based on that if he had been more familiar. So wouldn't that have been an improper stop?
I believe, Your Honor, at the time I asked Officer Uberoth the question, at the time of the stop, he believed that that was an illegal turn.
So that makes the stop legal because he believed that the law, because he was incorrect about the law, makes everything that he does and everything sees that after that non-poisonous?
Not necessarily, but I would argue that he had reasonable suspicion under his belief at the time that that was a legal stop.
Okay, well, he's conceded on the record that he changed his mind. Did he not?
After showing the statute, yes, Your Honor.
Thank you. Argument.
Just briefly, Your Honor. Your Honor, I think this was just this officer testified that he first saw these individuals on Willow and Roosevelt. He got behind them, he followed them for a while, they turned on the MLK, and then they made a quick turn and he kept going. And then somehow by some miracle, he ends up right behind them again shortly thereafter. I don't want to call this profiling, but that's what it looks like to me. He says that he makes up to 4 traffic stops per day, give or take 1 or 2. And each one of those stops, he asked the individuals, or almost all was what his term was, if they have a weapon in the car. I've been stopped hundreds of times. I'm a sports car driver. I've never been asked if I had a weapon in my car, Your Honor. And again, he may have made an honest stop. He may have thought that that was a legitimate stop, but just based upon his testimony, the code that we had entered as an exhibit under the Michigan Motor Code 257.647, specifically C and D, we know now that this was not a legal stop. It was an unlawful stop. He tried to backtrack and say, well, yeah, I could have stopped him for tinted windows. Yeah, I mean, I would have to familiarize myself with it again, but he testified that his basis for stopping them was this alleged unlawful turn, which was not unlawful, Your Honor. And everything that happened after that stop is poisonous. Using your term, Your Honor, it comes from the poisonous tree. Your Honor, at this time, we are asking that the court dismiss these charges based upon the fact that that stop was an illegal stop. Thank you.
Mr. Abbott.
I agree with her. Your Honor. Thank you.
Really? That's all you got? Okay. Today's the date and time set for preliminary examination. At the time of the preliminary examination, the burden is squarely upon the prosecution to establish sufficient probable cause that a crime was committed and that you all committed the crime. It's the court's responsibility at the time of the preliminary examination to first weigh the credibility of the witness and to determine whether or not the prosecution has likely ability to establish guilt at trial. I also need to measure whether the evidence raises reasonable doubt about the defendant's guilt. In this case, we hear a testimony from Officer Uberoth, who stated that on or about July 11, 2023, in the area of West Saginaw and MLK, which is in the city of Lansing, Ingham County, state of Michigan, making venue before this court appropriate, that he made a traffic stop upon a vehicle due to a moving violation. He said he relied on the improper turn statute to effectuate that stop. He said that the driver immediately put his hands outside the vehicle. He identified in court the driver as a Michael Robinson, and that the passenger being a Malcolm Robinson. He said that they didn't immediately provide proof of insurance, that the defendant, who was the driver, was rummaging through a red backpack. Looking for that, officers located a firearm later in that red backpack. There was no valid CPL. He said he ran the defendant, Michael Robinson's information in the law enforcement information network and determined that his CPL was suspended, or expired, I should say, had been expired for a couple of years. And that the passenger, that being Malcolm Robinson, had 2 outstanding felony warrants, and that the passenger was taken into custody on those warrants, that once he brought the information back to the passenger about a firearm being located, that the passenger, Malcolm Robinson, also indicated that he too had a firearm in the vehicle in a blue backpack, and that he believed that his CPL also was not valid. Officers did locate that second firearm in the vehicle. When officer was cross-examined, he was specifically asked if he was familiar with the statute that he claims to have relied on in making that stop, and that if he had, if he was to be refreshed, if that would help him understand the language. And so the officer read the language here in the court today, and after molding that language over a couple of times, I think it's undisputed that he stated that if he had a better understanding of the language in the statute that he claims he relied on, he would not have effectuated that stop. It's possible that he would have effectuated stop for something else if he had the reason to do so, but that we don't have that before the court. We don't know if there were tinted windows or if there were any other reason for him to make the stop. I can't say just based on what I hear today that Officer Baroff was profiling. He said he was traveling down MLK. That's possible. I don't know. You all saw the video. I'm sure I did not. Nonetheless, I have no reason to believe that he made that stuff just based on him profiling. However, he was willing on the record to correct his error and admit he was wrong about the basis upon which he effectuated that stop. I think it's a well-known, undisputable understanding, at least among legal professionals, that if there's an illegal stop, anything that's seized after that is poisonous. So because of that, these cases are dismissed for a lack of any evidence because there were unlawful stops. That's for you, Mr. Abbott. That's for you. Thank you.
Thank you, Your Honor.
Any additional matters for the record?
Nothing from the people, Your Honor.
What for the defense?
Thank you, ma'am.
Thank you.
Sure. We have David brought up, and are we running Walensky?
Yes, Your Honor.
Okay, and we're running Vivas, correct?
Yes, Your Honor.
But we will bring up Daly because that's a waiver.
Yes.
And then we'll run Olivas immediately. On the record in the matter of the people of the state of Michigan versus Darion Julian Major, file number 23-02829, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Major.
Okay, Mr. Major, today's the date and the time set for preliminary examination. Counsel, you said there's going to be a waiver.
That's correct.
Are the people waiving their exam?
Yes, Your Honor. The people would also agreed on conditionally waive the exam and move that this be found over as charged to certain court.
Was there an offer or negotiations continue?
I believe negotiations are to continue, Your Honor. The offer right now is complete as charged.
Your Honor, there was also an agreement that the prosecution would consent to an HYTA petition.
Okay, so, Mr. Major, you understand that you have the right to have a preliminary examination in the district court?
Yeah.
You understand the purpose of the preliminary examination, sir?
Yeah.
Okay, so you have the right to require the prosecution to put on evidence to establish whether or not a crime was committed or whether or not they have sufficient evidence to charge you with those crimes. You understand that?
Yes.
You're willing to unconditionally waive your exam today? Anybody threatening you to get you to do that? Any promises being made to you if you waive your exam?
No.
Okay, I bind the matter over for a bind over date of November 15th. You do not need to appear in court November 15th, okay, sir?
Mhm.
Is that a yes?
Yes.
Okay, that's just the date that the circuit court's gonna get the file from this court. Your next court date's gonna be a pre-trial in circuit court. Ms. Robinson will be made aware of that date, okay?
Okay.
Bond was set at 2,000 personal reconnaissance. That will continue. Has your address changed since October 17th or your phone number?
My phone number.
Okay, did you make sure your attorney have your new phone number?
No, so I'll give it to you.
Okay. Okay, make sure your attorney has that number and you appear for all your future court dates. Do you have any questions at this time? Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set, sir.
Your Honor.
Yes. Okay, he's gonna bring up Bailey and then we'll run Mr. Olivas.
Yeah.
Who is this? Yes, Mr. Daly?
Yes.
Okay, on the record in the matter, the people of the state of Michigan versus Logan Daly, file number 23-03126, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Daly, the gentleman's to my right.
Okay, Mr. Daly, today was the date and the time that was set for preliminary examination. And my understanding is that there is an unconditional waiver to the circuit court. Is that accurate?
Yes, Your Honor, that's my understanding.
That's accurate.
Okay,
And we've already, for the record, Mr. Daly and I have already executed the form.
I have it here. And the people are waiving their exam as well?
Yes, Your Honor, people would also on condition, permission to approach.
You may. Okay, and so you understand, sir, that you have the right to have a preliminary examination in this matter here in the district court. Okay, you understand the purpose of the exam?
I do understand.
Oh, so you have the right to require them to meet their burden of probable cause. So they have to establish that they have probable cause that a crime was committed and then probable cause sufficient to charge you with the crime. You understand that? And you wish to unconditionally waive your examination? But I just asked a different question. Do you wish to unconditionally waive your examination? Okay, you sure? Oh, okay, that means that you can't come back later and have your exam. You waive this exam and then the matter's gonna go over to the circuit court. You understand that? Okay, anybody threatening you to get you to waive your exam? Has there been any promises made to you?
No, mayor.
No promises made to you to get you to waive?
No, mayor.
Okay. Your bind over date's gonna be November 15th.
Say it one more time.
November 15th is your bind over date, but you don't need to appear in circuit court on that date, okay? That's the date that they're gonna get this file over at the circuit court. Your next court date in circuit court is going to be a pre-trial, okay?
Yes, ma'am.
Okay, last time we saw you, we did not have a address or phone number. Is that still accurate? Okay. Is there an offer at all?
The offer in this case would be for Mr. Daly to attend mental health court in the 30th Circuit Court, Your Honor.
Okay, and so that'll be noted here in the file. Bond was set at 15,000, 10%. That will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor, I have no reason to argue bond today. He's got other matters that are holding him in custody anyway. He might as well be.
Okay, sounds good. Do we need to call them to have him retransported or are they gonna just gonna? Okay, sounds good. Yes, sir.
I have insufficient funds. If I, everything was to do money wise, I just want to say, I wanted to please obey the law.
Okay, sounds good. You want to be able to obey the law, you said? Okay, that's what we want for you too. Oh, okay. All right, do you have any questions? Okay, you're all set. Thank you. Okay, and I don't see Mr. Abbott.
He just stepped out.
Okay. And then we're,
Ms. Porter, Judge.
okay, sounds good. On the record in the matter of the people of the state of Michigan versus Betty May Porter, file number is 23-02333. Appearance, please.
Jeff Brodowitz on behalf of the people, Your Honor.
Karen Robinson, Assistant Public Defender, standing in for Ms. Donnelly for Ms. Porter.
Okay, Ms. Porter is present here in the courtroom. Today was the date and the time that was set for a review date. We were here back in August. I found, or actually the defendant waived the 21 days. Ms. Donnelly indicated that she was going to petition to have the defendant evaluated. We reached out to the forensic after I didn't even see anything in the file. She never filed anything to petition, so I don't know how we're proceeding.
Yes, Your Honor. At this time, she's requesting that this be set for a preliminary exam date.
You do December 29th at 9.
December 29th at 9 AM. Do you have any questions today, ma'am?
No.
Okay, I will get you a copy of your notice for your next court date. Any additional matters for the record today?
Nothing from you people, Your Honor.
No, Your Honor, thank you.
Thank you. Thank you for filling in. You're all set, ma'am. You have a seat. We'll get you the notice.
Yes.
Okay. Did we see Anitris Morris present?
I
Or
don't
did I already
believe,
do a warrant?
I believe you already signed the warrant. if I
Okay,
remember.
sounds good. And then, so we're just gonna do, we have all of us and then Walensky who's in custody.
Yes.
Yes.
You can be seated.
Okay, on the record in the matter of the people of the state of Michigan versus Marcos Olivas, I have found number 23-03154, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott, representing Mr. Olivas, he's standing to my right.
Okay, today was the date set for preliminary examination, and my understanding is that we're ready to proceed.
That's correct, Your Honor.
We're ready, Your Honor.
Any preliminary matters?
The sequestration will be run with two witnesses.
Where's your witnesses?
That one is out in the hallway and the other is in.
One officer?
Yes, one.
Oh, the sequestration order is granted. Any other preliminary matters?
No, thank you.
You can call your witness.
Thank you, Your Honor. The people would call Mr. Clarence Christie.
Raise your right hand. Your other right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can have a seat, sir. Okay, so there's a microphone that's in front of you, and the person behind you, she's my court reporter, so she has to take down everything being stated here in the court. So I need your responses to be verbal. I need them to be loud and clear, okay?
Yes, ma'am.
If there's an objection that's made by either of the attorneys, you would stop speaking. I'll make a ruling on that objection, and then I'll tell you if you can make or give that answer or not, okay? State your first and last name and spell them both.
Clarence Christie, CLARENCE, CHRISTY.
You can proceed, counsel.
Thank you, Your Honor. Good morning, Mr. Christie.
Good morning.
Mr. Christie, do you know an individual by the name of Marcos Olivas?
Yes, sir, I do.
And how do you know him?
He is our next door neighbor.
Okay, and do you see Mr. Olivas anywhere here in the courtroom today?
Yes, sir, I do.
Can you please just indicate where he's sitting in an article of clothing he's wearing?
To the left of me with a black hoodie.
Please let the record reflect the witness has identified the defendant.
No objection.
Identification is noted.
So you stated that Mr. Olivas is your neighbor. What is your address, sir?
628 Leslie Street.
Okay, and what's Mr. Olivas's address?
624.
Okay, and are those locations in the city of Lansing?
Yes, sir.
In Ingham County?
Yes, sir.
All right, and were you at your house on the evening of October 15th, 2023?
Yes, sir.
All right, and did you encounter Mr. Olivas at that time?
Yes, sir, I did.
Okay, can you please describe for the court how that incident began?
I had just pulled in, backed my truck into the drive. I had gathered some stuff that I had to have for the house. I got out of my truck. As soon as my door shut, I heard a distinct noise. I looked up. I had a assault weapon pointing at me and the words, "I'm gonna kill you."
Okay, just back up for a second, sir. So you said you heard a distinct noise. What noise did you hear?
The racking of rounds.
Okay, so you described it as the racking of a round. How, I guess if it was behind you, how do you know that's what that sound
It
was?
wasn't behind me, it was right directly in front of me.
Okay. But how do you, I guess, are you familiar with the sound of a round racking?
Yes, sir.
And how are you familiar with that?
I was in the Army for 2 years.
All right. And you stated that you had a firearm pointed at you. Can you describe the firearm?
Roughly 2.5 to 3 foot long, rather narrow, black in color.
Had you seen any firearm that looked like that before?
No, sir.
Okay. So, at this time, permission to approach, Your Honor?
Yes.
All right, Mr. Christie, at this time, I'm going to show you what's been marked as People's Exhibit 1. Can you just take a look at that for me really quick? And Mr. Christie, do you recognize what's in that picture?
Yes, sir, I do.
And how do you recognize it?
That's the weapon I was looking at.
Okay, and is that that's a fair and accurate representation of the rifle you saw?
Yes, sir.
Okay. At this time, people would move for admittance of People's Proposed Exhibit 1.
Any objections to people's one?
Like what your opinion, Your Honor?
You may.
Thank you. Did you take that photograph, sir?
No, sir, I didn't.
Do you know when it was taken?
No, sir, I don't.
Do you know where it was taken?
No, I don't.
Do you know if that photograph is actually an accurate photograph of the gun that was there that day, wherever it was?
That's the weapon that was pulled on.
As far as that photograph goes, do you know whether or not that photograph is actually an accurate picture of that particular gun?
Yes, it is.
How do you know
If I can remember what I saw.
that? But you didn't take this picture.
No, sir.
This could be a picture of any gun.
Could be, but I highly doubt it.
All right, thanks. Your Honor, there's been really no foundation for the photograph since he's not the maker of the photograph. We can't really testify as to whether it truly accurately describes the object that was photographed on the gun. Whether or not it looks like the gun was pointed out at him is a different story, but whether this photograph is in this book.
Okay, do you want to respond to the objection?
Yes, Your Honor. First of all, the picture of the photograph is not needed here to verify the photograph. Mr. Christie has testified that that is the weapon that was pointed at him. However, I can lay further foundation with my next witness, Your Honor.
Okay. He's testified that this photograph of this particular weapon is completely inaccurate as to what he described to have seen that day. He doesn't dispute that he didn't take the photograph. I'll admit it with objection, and you can lay further foundation with your next witness.
All right, thank you, Your Honor. And so just getting back to what you're saying, so you're kind of back up. So you said you got out of your truck, you heard what you described as the sound of a round racking into a rifle. You turn around, see a rifle pointed at you, correct, is what you
Yes,
testified
sir.
to? Okay, and then I believe you said, but just to clarify, did Mr. Who was holding that weapon at that time?
Marcos was.
Okay, and did Mr. Olivas say anything to you at that time?
I'm gonna kill you.
Okay, and what was your feeling at that time, sir?
My body went numb. My hands lit in the air with my cell phone. I said, Marcos, pull the trigger, my daughter's on the phone.
And what happened after that, sir?
For whatever reason, he put the weapon down and he came out and attacked me.
And when you say he attacked you, can you describe to the court what happened?
He grabbed me, shoved me backwards against my truck. How I was able to get to my house, I have no clue.
Okay, and when you say he shoved you into your truck, where exactly did he shove you?
As in,
Like where on your body were his hands?
his hands were on one arm, and I'm not sure where the other one was.
Okay. And I believe you said that, but do you know what made Mr. Olivas stop?
The only thing I'm suspect is when I said, called his name and told him my daughter was on the phone.
Okay. And so after Mr. Olivas stopped his assault, what did you do after that?
I was inside my house on the phone,
And who were you on the phone with?
LPD.
Okay. And did LPD officers respond that day?
Yes, they did.
Okay. And do you remember the name of the officer you spoke with?
No, sir, I don't.
Okay. No further questions, Your Honor.
Cross exam.
Thank you. Just to clarify some of the images we're looking at, your address is 728, 628, and his is 624.
Yes, sir.
Those houses are right next to each other.
Right next to each other.
You share a driveway.
Yes.
Do you share a garage as well?
No, sir.
Separate garages?
Yes, sir.
Is this, this is kind of an ongoing disagreement, or you're unfriendly neighbors? Is that a fair description? You're not getting along very well?
Well, to do that, I'd have to speculate and say what everything else, which is rather, it's got nothing to do with what happened. I have no vengeance toward him. I didn't have.
Okay. But you and he have been arguing over the last few months, occasionally?
He just don't like me.
And you don't like it?
I don't like him and I don't dislike him.
Okay. Did you ever send a Facebook post message to him that says certain individuals wanted to wake the devil up? I'm awake. You're not going to like me. Don't know when, one by one, you're going to sleep.
Your Honor, I would object to relevance at this point.
Did you want to respond to the objection?
Your Honor, in terms of threatening behavior leading up and provocation leading up to these alleged events.
It goes to credibility. No objections overruled.
Did you ever send a message like that to him?
I do remember I said, because I went, I found his girlfriend's Facebook thing.
You said what? You found what?
I found her, I typed her name in and found her Facebook.
Did you send that message to her?
I sent a message saying that, because they kept doing it. I'm just trying to get them, leave me alone. I'm 61 years old.
Okay, but you did send that message?
I don't remember exactly what I said. But yes, I sent a message.
Was it a threatening message like that?
I don't believe it was threatening.
And did you say anything before you heard the gun racking?
No, sir.
Had you had any contact with him earlier in the day?
No, sir.
Had you had any contact with his girlfriend earlier?
No, sir.
You're saying they're just out of the clear blue sky, as you're getting out of your truck, he's pointing a gun at you?
Yes, sir.
Have you ever threatened him?
No, sir.
You ever pointed a gun at him?
No, sir.
You ever pointed a gun at his girlfriend?
No, sir.
Have you ever threatened her?
No, sir.
So the police came that day?
Yes, sir.
And did they see Mr. Olivas?
They got there. The officer came in and talked for a few minutes. He left. He was over next door. I don't know what was going on. I could hear a lot of yelling on their behalf at the officers. That went on. The officers were there until just after 4:30 that morning.
So this happened at night?
Yes, sir.
So it started after dark?
Yes, sir.
And it ended before the sun came up?
Yes, sir.
Right. How far away was this person that was pointing the gun at you?
12 foot, 14 foot.
Are there any lights in the back of the house there?
Yes, sir. Back porch.
Back porch lights on your house?
On their house.
Okay, so person that was standing, was this person standing on the porch?
Yes, sir.
Was the light behind him or in front of him?
Above him.
Thank you. Nothing further, Your Honor.
I guess what were you doing before this happened, sir? You were just sitting on your porch?
No, I went out and visited a friend of mine.
Oh, you were walking into your
No.
house? Where were you?
Yeah, no, I pulled my truck in the driveway. I
Okay.
backed in. I got out. I had soap for the carpet because I was gonna shampoo the carpet.
Okay, so you were just coming home?
Yes, ma'am.
Oh, okay, got it. Okay. Any redirect,
Nothing from the people, Your Honor.
cross-examination based on my question?
No, thank you.
May this witness be excused?
Yes, Your Honor.
Okay, Mr. Christie, there's a sequestration order. So that means that you can't discuss any portions of your testimony with any other witness, okay?
Yes, ma'am.
Okay, you can be excused. You can call your next witness.
Thank you, Your Honor. The people would call Officer Jake Ellis.
Your Honor, if I may,
Yes, sir.
he's charged with felonious assault, felony firearm, and assault and battery.
Okay.
May I approach?
So I can't see how any additional testimony is going to change your mind one way or the other. If you found this witness to be even a little bit credible, it's going to get bound over on the charges. I don't see any necessity for anybody else.
Well, there was some foundational information you wanted.
Well, even if the photo doesn't come in here.
That's true, because I haven't seen the photo and he didn't publish it. So did you, what is your next witness supposed to do other than admit that exhibit, which really isn't necessary?
Yeah, the testimony of Officer Ellis would be to how the police responded and then the recovery of the firearm, establishing that it is a legitimate firearm, Your Honor. Which is, I believe, one of the necessary requirements for the charge of a felony firearm.
Dangerous weapon. Okay. You can call your witness.
All right, thank you, Your Honor. The people would call Officer Jake Ellis. I can whittle the testimony down when you're on.
Very good. You got about 22 minutes before
I can do.
you need to be done. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you, officer. You can have a seat. And you can state your first and last name and spell both.
J Ellis, JAELLIS.
You can proceed.
Thank you, Your Honor. Good morning, Officer Ellis.
Good morning.
Officer Ellis, how are you employed?
The Lansing Police Department,
And how long have you been a police officer with the Lansing Police Department?
4.5 years.
And were you working in that capacity on October 15th, 2023?
Yes.
All right, and did there come a point in time when your duties took you to the address of 624 Leslie Street?
Yes,
All right, and that's located in the city of Lansing, Union County?
that's correct.
All right, and why were you dispatched to that location?
We were initially dispatched for a weapons complaint.
Okay, and when you arrived on scene, did you get a statement from the individual who called?
Yes.
Okay, and after you received that statement, how did you proceed?
Once the statement was taken, talked with command. The intention was to potentially call out our tactical team, solve the issue if residents inside 64 Leslie didn't exit the residence. I began to do a preliminary type of search warrant. As I was beginning to type that search warrant out, they both exited the residence.
Okay, and when the individuals exited the residence, were they cooperative?
I wasn't there for that part. I was in my patrol vehicle, so I didn't go with help necessarily.
Let me just- Did you ever conduct a, I guess I could just skip over it. Did you ever get a search warrant for that address?
That's right.
Okay, and did you recover any firearms during that search?
Yes, we were 4 firearms.
Okay,
You said you recovered how many?
4.
permission to approach, Your Honor.
Okay.
I'm going to show you what's been admitted with objection as People's Exhibit 1. If you could take a look at that. Officer Ellis, do you recognize that photo?
Yes,
And how do you recognize that picture?
that was one of the firearms that we seized from the residence.
Okay, and did you recover that firearm?
Yes,
And is that a fair and accurate representation of the firearm you recovered?
yes,
All right, at this time, people would move for admittance of people, so exhibit 1 over the objection.
This one's a minute.
All right, and when you found that firearm, was that firearm loaded?
There were 223 caliber rounds in the magazine. Magazine was inserted into the weapon. There was no rounds in the chamber.
Okay, and could you tell, based on your training and experience, were those live rounds?
Yes.
Okay, and just to clarify, you wrote in your police report that it was a 22 caliber, and I believe you just testified that it was a 223.
That was a type of extremely tired of that part of the report.
Okay. And did that weapon match the description of the weapon you received from the complaining witness in this matter?
That's right.
Okay. No further questions, Your Honor.
So you can first again.
Good morning.
Good morning.
You up all night? So you found this weapon in that house?
That's right.
And you testified that there were no bullets in the chamber.
That's right.
So if somebody had racked around in the chamber,
That's right.
had they done so minutes before, that would mean that there'd be a bullet in the chamber
At that moment.
at that moment. So the gun that you found did not have a bullet in the chamber. No, it didn't.
No, I didn't have a round.
So in order to go from a condition where there's a round in the chamber to no rounds in the chamber, but rounds in the magazine, is it your understanding that someone would have to take the magazine out and then rack the live round out and then put the magazine back in?
That's right.
Nothing for
You redirect.
Just briefly. Officer Ellis, between the initial call and the recovery of the firearm, about how much time would you say elapsed?
6 hours, maybe.
Okay, and may sound like that question, but would that be enough time for somebody to unload, take the magazine out of that weapon, unrack any round, and then replace the magazine?
Yes.
Okay. No further questions, Your Honor.
Okay, may this witness be excused?
Yes, sir.
The officer, there's a sequestration order, so you can't discuss any portions of your testimony with any other witnesses, okay?
Sure.
Thank you.
Permission to public people's one report. Your Honor?
Yes. Is the defense calling witnesses?
not today, thank you.
Proceed to argument.
Thank you, Your Honor. People would move after hearing testimony that this be found over to the circuit court as charged in the complaint. We heard testimony from 2 individuals, the victim in this matter, Mr. Clarence Christie and Officer Jake Ellis. Mr. Christie testified that he arrived home on October 15th, that when he exited his vehicle and was getting some stuff out of his vehicle, he heard a noise behind him that he identified as someone racking around into a rifle, or racking around into a weapon, turned around to see the defendant, who he identified here in the court as the individual holding said weapon, described the weapon as about 2 to 3 feet long, black in color. He also testified that the individual standing on their back porch, and that the back porch was lit, even though it was after sunset. He also testified that when the individual was pointing the firearm at him, he said that he would kill him. He testified then that he threw his hands in the air, said that his daughter was on the phone, and then the individual put the weapon down and came over and proceeded to assault Mr. Christie. Mr. Christie then said he managed to make it into his house somehow and call 911. We then heard testimony from Officer Ellis, who testified that after taking a statement from the individual and conducting a search subject to a lawful search warrant, that he recovered a firearm matching the description of the one described by the victim in this matter, that firearm had a loaded magazine with live rounds in it, which would make that a firearm for the purposes of the felony firearm charge, Your Honor. So with that, people believe they have met their burden by probable cause evidence that the defendant, Mr. Marcos Olivas, did make an assault upon Mr. Clarence Christie with a dangerous weapon, to which a firearm, and that firearm was an actual firearm, Your Honor. So people would move that this be bound over to circuit court as charged in the complaint.
I'll leave the bind over to the court's discretion. Thank you.
We have a date and time set for the preliminary examination. The burden is on the prosecutor at the time of the examination to establish they have sufficient evidence for probable cause. So that's probable cause that a crime was committed, and then probable cause sufficient to charge you with the crimes. And so this is more than just mere suspicion that a crime was committed, but not as much evidence that would be needed in order to prove your guilt at trial. That's beyond a reasonable doubt. It's a much larger burden, okay? The court is the sole determiner of credibility at today's hearing, and the court will weigh the evidence and determine, based on the evidence submitted today, whether or not people have a likelihood of success at trial. So we have the testimony today of one witness, first being Clarence Christie, and then officers Jake Ellis. Clarence Christie testified that on the date of October 15, 2023, in the area of 625 Leslie Street, which is located in the city of Lansing, Ingham County, state of Michigan, that he was returning home when he heard what he described as a distinct noise, and that it was the racking of a round. One question is how he was able to distinguish that noise that he heard to be the racking of a round. He indicated that he served in the Army for 2 years. He stated that he then saw a gun pointed at him, and the person he identified in the court as Mr. Marcos Olivas, or Olivas, correct? Mr. Olivas stated allegedly to him, "I'm going to kill you." The defendant, the victim actually described a firearm, and when shown what's been marked now and admitted as People's Exhibit 1, which is a black long firearm, he indicates that that is the firearm that he recalls being used in the commission of the alleged assault. He then indicated that he was attacked by the defendant and pushed into, or by the defendant shoving him allegedly into his truck. Officers were called, and Officer Jake Ellis reported to the scene of the incident. He was dispatched for a weapons complaint. He said he took about 6 hours before he got there, that he obtained a search warrant for the address. He obtained several firearms. I believe he said the number was 4, and the firearm which was described to be used in the commission of the alleged assaults, he indicated had no bullets in the chamber at the time that he recovered it, but when questioned on redirect, he indicates that, of course, the time frame in between the initial dispatch and the time in which the search was conducted would be sufficient enough time for a firearm to be rendered safe and or to have the round removed from the chamber. The count 1 has been charged as assault with a dangerous weapon, also known as a felonious assault. In order to prove that at a trial, the people would need to then prove beyond a reasonable doubt, first, that the defendant either attempted to commit a battery upon Mr. Christie or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of the person of another or something closely connected with the person. Second, they would need to prove that the defendant intended to either injure Mr. Christie or to make Mr. Christie reasonably fear an immediate battery. Third, at the time the defendant had the ability to commit the battery, appeared to have the ability or thought that he had the ability. And fourth, that the defendant committed the assault with a dangerous weapon. It describes a dangerous weapon to be any object that is used in a way that is likely to cause serious physical injury and or death. Based on the testimony today, there was a testimony of an alleged interaction that involved the defendant pointing a firearm, which we know to be undisputed as a dangerous weapon, and at him stating, "I will kill you." And that at the time, he was in close proximity, close enough for the victim to give what he described to be a description of the firearm. So the court is satisfied that there is sufficient probable cause as to count 1 to bind over as charged. Count 2 is weapons, felony firearm at the time of trial. In order for the people to prove that, they would need to prove each element beyond a reasonable doubt first, the defendant having allegedly committed or attempted to commit the crime of felony firearm, which has been defined, and it will define felony firearm as the use or possession of a firearm either to complete or to attempt to complete a firearm. It says an attempt has 2 elements. First, the defendant must have intended to commit the crime of the crime, in this case being assault with a dangerous weapon, or made preparations for committing the crime. Things like planning the crime or arranging how it will be committed are just preparations. They do not need to qualify as an attempt. In order to attempt, the act must clearly and directly be related to the crime the defendant is charged with attempting and not some other objective. This is not being charged as an attempt, but as a weapons felony firearm. And the allegation is that the defendant allegedly used a firearm, that being a rifle, which has been described here and pictured in People's Exhibit 1 in the commission of the act of assault with a dangerous weapon. So the court is satisfied as to count 2, and that will be bound over to the circuit court with count 1. Count 3 is a misdemeanor assault and battery. We do not need to address probable cause because that is a misdemeanor. So all counts as charged will be bound over to the circuit court for a bind over date of November 15th. That's the date the circuit court gets the file from the district court. That's not a date that you need to appear in the circuit court, okay? Your next court date will be a pre-trial in circuit court. Mr. Abbott will be made aware of that date. He'll be in contact with you, okay? Bond was set at 5,000 personal recognizance with a no contact order in place for the protection of Mr. Christie. There is a pending or outstanding bond violation. I'm going to dismiss it at this time. I'm going to remind you that there's a no contact order. You're not to have contact directly or indirectly with Mr. Christie. You're not to cause any third party to relay any messages or communicate on your behalf in any way with Mr. Christie. Do you understand that?
Yes, Judge.
Do you have any questions about the no contact order?
No, Judge.
Okay. Any reason why we need to address bond in any other sense?
Nothing from the people, Your Honor.
Not from the defense, thank you.
Okay, bond will continue. You're all set.
Thank you, ma'am.
You're welcome.
Yes, sir. Thank you.